Hey guys, sorry about running just a little bit late. Had some technical difficulties. So I want to take just a moment and go ahead and let's get right into this. What happened today? Well, there was an appeal. There was at least an effort to start the appeal. There was this motion filed by the various defendants in the case. It's called an application for a certificate of immediate review. So let's take a minute and just look and see what this thing looks like. Joint motion for certificate of immediate review. Under Georgia law, it's important to remember that you can't just appeal anything that you want pre-trial. Normally, you got to save up all of the issues for the appeal and do them all at the very end of the case after perhaps the jury's convicted you. And this would be just one of the many issues, but sometimes things are so important that you got to go ahead and get them out of the way early. So let's see what they're telling the judge. They're saying, Judge, your order of March the 15th is so important that it is exceptionally great importance to the case, substantially impacting the defendant's right to due process. It's so important that we need you to let us go at this point in time now and get this issue addressed once and for all by the Court of Appeals before it's too late, before we have a trial by a prosecutor that the defendants say is unfair, that is biased, that has a personal interest in the stake. And by the way, this odor of mendacity remains hanging over the case. There's an appearance of impropriety, they say, and there's an odor of mendacity that lingers in the case. And so they want the Court of Appeals to go in and clear up that odor and see if they can make it go away as you were. All right. So they point out to the judge that an outsider, that's us, looking in on this, could reasonably think the DA is not exercising her independent professional judgment, totally free of compromising influences. They go on to point to the judge that, look, Judge, if you don't allow us to go ahead and correct this issue now, then it could come back to haunt you. And what they mean by that is they're saying if we don't get the opportunity to appeal this now and get the Court of Appeals to say once and for all whether you got it right, because after all, Judge, they're saying there's a lack of definitive instructions from the appeals courts on these things. You might have to come back and do this all over again after you've had all these, trials in the case. And he's already talking about possibly breaking it up into batches of 2 or 3 trials anyway. But if there's a conviction for any of the defendants and there's the case is appealed, the Court of Appeals could very well say, you got it wrong, Judge, on that March 15th order to disqualify. So now we've got to send it back and you've got to do it all over again with a new prosecutor. So this is the kind of thing that they want to get done right, and they want to get it done now. They also point out, by the way, and I think this is correct, that if there was some type of problem that required the judge to intervene and start kicking prosecutors off the case, they point out that it doesn't make much logical sense to get rid of one without getting rid of all of them. And I agree with them. I think that doesn't make a whole lot of sense, that eliminating only the special assistant DA would cure the lingering appearance of impropriety. They keep using this word lingering appearance of impropriety and the lingering odors. And it really does paint a very powerful, I think, mental image. And it's pretty impressive legal writing here using these descriptive phrases such as lingering. I love it. All right. So anyway, it doesn't make sense to me how you correct this appearance of impropriety by getting rid of one and not the other, because if what they have done up to this point creates this this situation where the entire matter is tainted, then I think the only thing to do is to send it back to the drawing board with a new prosecutor and to disqualify the existing one. But in any event, that's what they're asking the judge to do. And then they move on to something else that, in my opinion, has not been really addressed enough. The issue, what is this forensic misconduct? What is forensic misconduct? All right. Well, forensic misconduct is a fancy legal phrase that means the prosecutor's talking bad about the defendant outside the courtroom, and it impacts the defendant's ability to get a fair trial. So what they referred to is this nationally televised speech at Big Bethel AME Church in Atlanta on January 14th. The judge actually found in his order that it was legally improper. So if something is legally improper, you know what you got to do about it. If something's legally improper, you got to fix it. You can't just give her a slap on the wrist and say, please, pretty please, don't do it again. And he even went so far as to say, well, maybe it's time to think about a gag order. Well, you think, and do you think if there is a gag order that that's going to really stop Fani Willis from saying something bad about these guys? No, she's got plenty of people willing to speak for her that can do the job on her behalf if that's what she wants to do. She's got to be punished, if you will, for taking steps that undermine the defendant's ability to get a fair trial. Who do you think was in that church? It's the jury pool. It's the potential jurors from Fulton County. That's who that's who those people are. Every one of them in that church is a potential juror. And so the remedy when a prosecutor engages in some type of wrongdoing that impacts the ability to have a fair trial, at a minimum, I think, is to get rid of that prosecutor. So that's what this is all about with forensic misconduct. So let's see what else they have to say here. They note that in Georgia, we don't have a lot of guidance in our case law for what the standard is for disqualifying a prosecutor for this forensic misconduct. Again, that's talking bad about the defendants outside of the courtroom. So if there's not much guidance and the judge has to basically, if the judge has to, as the judge says in his order, divine what is meant by this Williams case that everybody's relying on, if the judge has to basically guess and figure it out, maybe it's time to have the Court of Appeals explain it to the judge so nobody's got to guess on what the standard is for disqualifying a prosecutor for forensic misconduct. Another good reason to go ahead and get this done now, get it done prior to any trials. I want to cut to the end. There's a lot of legal argument here. It's very good. I'll post the rest of it if you haven't found it, but I'll put it out on X later. They go on to point out that appellate review is needed of the March 15th order because she has this personal stake she's acquired in the prosecution. So I don't understand how the judge thinks that her stake is cured by the removal of Mr. Wade and only Mr. Wade. There's an argument that the state has made that she would have to have some financial interest in a conviction, or a stake, if you will, in a conviction. Well, I think she does have a stake in conviction, because what do you think happens to her politically if she gets a conviction? This is quite the trophy to hang on her wall, and she can basically write her political ticket from here on out. But she at a minimum had a financial interest, I think, in the existence of the investigation, which I think really ought to be enough, because having a personal stake simply in the existence of a case causes a prosecutor to be acting in their own interests and not in the interests of what justice and the law might require. This is a very, I think, well worded and very short document, but they go on to make this point in the conclusion that a criminal defendant is entitled to a disinterested prosecutor. You know, criminal defendants are entitled to lots of things. They're entitled to the right to be presumed innocent, their right to have a lawyer at all stages of the case. They have the right to a jury trial, and that means a fair court system and a fair process. And as important as all of those things are, it all starts with hopefully a fair-minded, objective prosecutor, because that person is the gatekeeper that causes everything else to happen, from indictment and everything that happens beyond that. So I think having an objective and a fair prosecutor who's disinterested in the case is just as important as your right to a jury trial, the right to be presumed innocent, the right to a lawyer, and all the other procedural safeguards that are designed to make the system fair. The last thing that that they point out here that I wanted to kind of mention here, it says that whether the DA is permitted to continue representing the state in this case is of the utmost importance, and ensuring the appellate courts have the opportunity to weigh in on these matters pre-trial is paramount. And they remind the judge, and I think they should remind him, should this review not occur until after any trial in the case, and these decisions are ultimately reversed on appeal, then that would require the retrial of every convicted defendant. Can you imagine having to do all of this over again because the judge doesn't let them take this issue up to the Court of Appeals? And by the way, it's important to remember that even if Judge McAfee allows the parties to appeal this, the Court of Appeals still could say no. You got to have permission of both the trial judge and the Court of Appeals. But I believe McAfee's going to give permission. I think he's going to grant this pretrial appeal, and I think that the Court of Appeals will take it. The arguments in favor of this are unbeatable. You cannot defy the logic in getting this thing dealt with and appealed prior to any trial. All right, so I want to see what some folks have to say over here. I want to see if I can just address a few of your comments and questions. Thank you, Judy. I appreciate that comment. Yep, and I'm sorry we were a little bit late starting. Sorry about that. Kind of had to get some technical things taken care of. I care nothing about conflict or appearance of a conflict. She committed perjury. You know, a lot of people have said the same thing, and I think that there's certainly that's what the odor of mendacity means. The judge believes that there are significant questions about that, and I think, quite frankly, that you ought to be entitled to a prosecutor who you don't have any questions about whether they've committed perjury. Maybe I'm silly. That's just my opinion. Christina, thanks for your analysis. Christine, I'm sorry. You're very welcome. Thank you for the comment. That's an interesting comment. That's not exactly what Roy Barnes said, but it's still funny. All right. I've heard this question too. Jody's asking, can they keep the work product from Wade? The answer, I believe, is yes, unless there's some other order to the contrary. And that's why, look, if his being part of this case was, improper to the point that the judge had to basically say, all right, it's one of you's got to go. You figure out which one. If it's that bad, then shouldn't his work product, the things that he's done, he's the one that presented the case to the grand jury, I understand. So that's part of the reason why I think that simply having them pick which one has to go is not going to be enough, because the fingerprints of Nathan Wade are all over this case. Everything that's happened has got his fingerprints on it. And so if it's tainted, it's tainted. You can't cure it by half measures, in my view. Everybody understandably and rightfully, and myself included, is talking about the allegations of perjury. Roxana points out she should be charged with that. And I want to make this point. Yes, that could happen, but it's going to require someone to refer the case to the Attorney General in the state of Georgia. That's the only way that could happen. But speaking more generally about allegations of perjury, I think that it's enough to disqualify her. That should be a separate and independent basis for disqualification. Misty says, and points out correctly, that that he was in fact paid. It's over 600,000 at this point. It's probably 700,000 or more, and that money is gone. It's in his pocket, or maybe some of it was spent on her. But in any event, that's over and done with. So yes, Judge McAfee did signal that the appellate courts were, and I think that the judge probably wants them to make this decision. He doesn't want to risk getting reversed after investing the time and effort and resources and money and everything that goes into all these trials, and getting reversed. What happens if Fani is held in contempt of Congress, which could happen very soon? I've been watching that, and it's certainly going to be interesting. As I understand, I'm not an expert on the inner machinations of Congress, but we've seen enough of this in recent history to know that you got to have a few votes, and you've got to have the vote of the whole Congress, or at least the House of Representatives. And it's hard to get a majority of them to agree on much of anything. It's hard to understand who is going to be in the majority from one day to the next, because you got people leaving Congress left and right and special elections. But in any event, you've got to have the votes. And then you would have to have the Department of Justice in D.C. decide to prosecute her. I think we can forget about that happening. There's no way that the Department of Justice in D.C. is going to be prosecuting Fani Willis for contempt of Congress. That's just my opinion. I welcome yours. All right. Do we know if any lawyers are going to be going after her about these lies and her conduct? Well, Rebecca, if I understand your question, what you're asking, is there anything else that any of the defendants going to do anything else? And the answer is, I believe so, but I'm not sure. I don't think, if I had to place a bet right now, I would say we've not heard the end of it. I think that maybe there's still some digging and some things that might be happening in the future. We might see some additional things being filed. It's too early to tell. We'll just have to wait and see. But you never know what's going to happen. Who conducts the immediate review? So I'm sure that I was less than clear in explaining that. So the application for certificate of immediate review is the defense asking the judge's permission to take this issue of disqualification up to the Court of Appeals prior to any trial. Normally, you've got to wait until there's been a trial and a conviction, and then take all of your allegations of error to the appeals court all at once. But sometimes when it's really important, you can do it ahead of time prior to trial. That's called an interlocutory appeal. The judge has to agree and say, you can do that. That's discretionary on his part, but it's also has to be agreed to by the Court of Appeals. So that's what the immediate review means. You're asking for immediate appellate review as opposed to waiting until the case is tried and somebody is potentially convicted. All right. The judge is playing chess. Well, it's possible the judge is playing chess. The judge doesn't want to get this wrong. I think he wants, if he's wrong, I think he would welcome the Court of Appeals to tell him he's wrong. So I think that's really all that he's going to want out of it. That's my read of him anyway. Fani going after Joselyn Wade. I don't know about that. And I've not been, admittedly, that's a piece of this that we haven't talked about or thought about in some time. I think that the divorce case in Cobb County between Mr. and Mrs. Wade, I think that's going to resolve itself. So whether or not something else happens, we'll just have to wait and see. I think that if she said she needed 6 months to gather evidence, I think that was just her meaning she really wanted to delay it at least 6 months, if not longer. All right. Well, I would love to, I didn't see the question, but if I can see it again, Faith, I will absolutely see if I can address it. Maybe somebody can post it again here in the more recent comments. with the way the Supreme Court argued today, I don't have faith in any judicial branch. Listen, this is something that we want to have faith in the court system. We want to have faith that they're going to get it right most of the time, but sometimes they don't. And that's why it's so important, by the way, that issues like this that are really, really big issues in a case should be addressed prior to any trial. Did they ask about this prosecutor's meeting with the White House? Oh, yes, that has been discussed, and certainly there's information there in Nathan Wade's billing records to suggest that. And that's part of what the House of Representatives and Jim Jordan's committee is looking into, as I understand it. It's not something for Judge McAfee. It's more the kind of thing that would be an issue of oversight, federal oversight of the I guess, the White House counsel's office. But it's not really a thing for Judge McAfee to address in the context of this particular case. It does show perhaps that there's some, if it's true, that there's some political bias here, but the direct oversight of that is through the Congress. Okay. We have Judge McAfee's rebuke, the odor of mendacity, her contempt of Congress. Fani doesn't believe in the rule of law. Cheryl says, do I think the governor or state legislature will do anything? So the governor has no role in Georgia at this point. The governor would only have a role if a constitutional officer, such as an elected DA, was charged with a crime. The state Senate is currently engaging in its own oversight. They have a special committee that the Senate here in Georgia has put together that has already started its work. They started with their first witness was Ashley Merchant. Now, the Senate can't directly punish Willis, but what the Senate can do is the Senate can help write laws to help make sure that none of this ever happens again. They can address conflict of interest rules and things of that nature. But the governor at this point has no role to play with regard to this particular case. All right. That's about it for tonight, folks. Tomorrow, Courtney Kramer, who's running against Fani Willis, is going to come in, and we're going to talk about her candidacy, why she thinks that she's the best lady for the job. And she's also going to share with us, I think, maybe what her thoughts are on this order and the conduct that the judge has attributed to the current office holder, Fani Willis. Even if the judge did not disqualify her, he certainly did not have nice things to say about her. The opinion, the way I read it on balance, was scathing. And it was the kind of thing that I would be embarrassed, mortified even, to have a judge write about me in discussing my conduct of myself, not only as a lawyer, but as a public servant. So with that, thanks everybody. Please like and subscribe. We really appreciate it. And we will, of course, be here as often as we can as things move. And otherwise, we will be back tomorrow with Courtney Kramer. So have a good night, everyone.